for determining distortion, nor do they have standards for the method of comparison. And that's evident from the state's own two witnesses. Dr. Souveron likes to show you his little overlays with little boxes, and you can call them points of comparison, and they fall within these boxes, and this is what makes it fits up real nice. And this is why it's Mr. Bundy's teeth, he says. Points of comparison. Dr. Levine tells you, you can't do it that way. You can't use points of comparison. Completely different methods. Dr. DeVore took his 5 models, brought his 5 models in here, showed them to you, blew them up to the same size as the pictures of Mr. Bundy's teeth, and shows you that Mr. Souveron's overlay, his so-called points of comparison, fit those models too. They have no scientific basis for their conclusions. They have no standards for determining the uniqueness of dentition and the uniqueness of bruise marks. They have no data bank. They have no place where they have stored models of teeth in order to make a statistical study to find out whether or not there are common reoccurring patterns of people's teeth. And Souveron and Levine don't even agree on what's the determination or what's the standard for determining reasonable dental certainty. Souveron goes to the dictionary. Levine says high probability without any statistical backing. You can see that Souveron and Levine are good speakers. They came across as confident, assured, and they do express their opinions in no uncertain terms. But the question that you have to answer, the question which you have to determine is, are those opinions worthy of your belief beyond and to the exclusion of every reasonable doubt? Their opinion testimony, reduced to what it really is that they're saying to you, is that, trust me, I'm an expert, I say it so. Does evidence of trust me, I say it so, does that amount to proof beyond and to the exclusion of every reasonable doubt? The judge will give you an instruction concerning how you should evaluate expert witness testimony. In evaluating the testimony of an expert witness, you should give it whatever weight you think it deserves. And the judge will instruct you that you may reject it entirely if you find that the alleged facts upon which it is based have not been proven, or that the reasons given in support of the opinions are not sound. That is the question here. Have they shown you the database? Have they shown you the scientific evidence to back up their opinions? In contrast to these conclusions, these opinions of the state's witnesses, we brought you the testimony of Dr. Gruey. Dr. Gruey is an orthodontist. He diagnoses and treats dental disorders. He has studied and researched, and he is familiar with the common occurrence of certain patterns of teeth in the mouths of the population at large. He's done research for WHO, which is the World Health Organization in Denmark, as well as being the head of the orthodontic clinic at the University of Maryland for about 10 years. He trains dentists like Souveron and Levine. He is an expert in the growth and development of teeth. He testified that he has seen over 15,000 sets of teeth, that he's examined them, that he's worked with them. Now the prosecution, their first disparaging question, and the first disparaging tone of voice on cross-examination is, you're not a forensic odontologist, are you? Well, he's not. There's no magic in those words because he has what the state's witnesses do not have. He has a scientific basis for his opinions. He knows the data, he knows the research, and he has the facts to back up his statement that Mr. Bundy's teeth are a common pattern for people with crowded lower teeth. The way Mr. Bundy's teeth are aligned are the way that he would expect to find the most common misalignment of teeth. We don't ask you to believe him about what he says, about what he knows about the data, about the common occurrence of certain occlusions or what he called a class 1, Dewey type 1 classification of teeth. Because the scientific studies stood behind his conclusions. Studies that he conducted long before he got involved in this case. Now, Dr. Gruey's not a showman, and he's not a professional testifier. But he provided what the state failed to show. Scientific backing for his opinion based on research and study and scientific facts that Mr. Bundy's teeth are not that unique. If you want to convict on the best show and on the confidence game, then maybe you'll accept what Sue and Levine have to say. But I implore you to heed the judge's instruction and to reject their opinions entirely if you find that the alleged facts on which they are based are not established in the evidence, are not proven by the state. Dr. Gruey also said that the chips in Mr. Bundy's upper teeth are not uncommon. In addition, I'd like to just point out here that the state took the pictures of Mr. Bundy's teeth and took the models of his teeth on April 27th. The state didn't prove to you that those chips were in his teeth in January. They're talking about models taken 3 months later, and chips in the upper teeth are not that uncommon. Dr. Gruey also said that a crowded alignment of the front teeth is very common. As a matter of fact, Mr. Bundy's teeth are not so bad as that he would even need orthodontic care for health reasons, for dental reasons, only for what he said were aesthetic or I guess beauty reasons. If you didn't like the way you looked, then maybe you would want to have your teeth straightened. They're not all that uncommon. It's a sad day for our system of justice. If a man can be convicted in our courts on the quality of the state's evidence, it can put a man's life on the line because they say he has crooked teeth without any proof that such are unique, without any proof, without any scientific facts or base or database to their conclusion. All citizens in our system suffer when the state can jeopardize a man's life or freedom by such flimsy, unsubstantiated opinion testimony. Now, Dr. DeVore went to Dr. Gruey's orthodontic clinic and brought you in some models to show you patterns of teeth that are similar to Mr. Bundy's. The state wants you to discount these models because of the age, because these models were taken from individuals that were from 12 to 15 years old. But that argument, the state ignores the very important part of Dr. Gruey's testimony. Dr. Gruey testified, based on his research, based on his studies, that once a permanent dentition to the first molar has been formed about the age of 12, then there's no appreciable change in the size of the lower arch until adulthood. Matter of fact, I think he described the measurement as 1 millimeter. Dr. Gruey was the only expert that was qualified to know about the significance of age as it relates to tooth alignment and development and growth. Don't let the state sidetrack you by saying those children were not in Tallahassee. Those children could not have committed those crimes. The purpose of showing you the models is not to say to you that those persons are suspects. The purpose of showing you the models was to show you that Mr. Bundy's teeth are not so unusual that only his teeth could have made that bruise mark. Dr. Gruey has shown you that the age of the models is not material. Don't be fooled by the saints, sidetracked, saying that the models are not accurate. Look at the evidence. Look at those models when you go back in there to deliberate. Take the transparencies that has the positive of the bruise mark on it and lay them over the teeth. Decide for yourself if the state has proven beyond a reasonable doubt that only Mr. Bundy's teeth could have made those bite marks. But Dr. Levine came in here on rebuttal and says he can exclude the models. But again, he didn't tell you any facts. He didn't give you any reasons for that opinion. He just gave you his opinion. I can exclude them, period. Again, he's saying to you, trust me, I say it so. It can be done. I can exclude them. But you're also to look to the reasons and the alleged facts on which the opinion is based, and he didn't tell you anything about that. Consider carefully whether you can buy this new opinion theory of identification, which is unsupported by a data bank of dental models, which even Dr. Levine says he wishes they had, which is based on examination, which reflects the examiner's bias. Dr. Levine came in here and said, when looking at those 5 models, he knew immediately which one was Mr. Bundy's. He's had Mr. Bundy model since August of last year, he says. He can identify it. He's familiar with it. He hasn't even looked for a database. He hasn't even looked for where other dental models are kept or stored or documented to determine what Dr. Gruey knows, that there are other patterns of crowded lower teeth that are similar to Mr. Bundy's. As far as the choice of the place for choosing the model, an orthodontic clinic is the best place and the logical place. First of all, that's where models are routinely collected. That's where they do work on people that have crooked lower teeth like Mr. Bundy's. It's also a convenient place to collect the models due to the time factor. Dr. DeVore told you that he was appointed in March. And there are practical difficulties to examining enough mouths independently of a place where there's already an established data bank to find models. And coupled with Dr. Gruey's testimony that the age of the dental patient makes no difference. Once their permanent dentition is set, then you can see that the models taken from this clinic was a reasonable database to go to show you that other teeth fit the bruise mark. And Dr. DeVore found at the orthodontic clinic what he expected to find. He found models which are virtually indistinguishable from Mr. Bundy's teeth. Hold Dr. Souveron's transparent boxes up to those large photographs. Look at the models. Examine the way the teeth are set, the way that they are in the same patterns, and decide for yourself. Decide for yourself whether the same pattern of crowded lower teeth fit the bruise pattern every bit as well as the models taken from Mr. Bundy. The purpose of the models is to show you that anyone with a crowded dentition like Mr. Bundy's would be in trouble if they were unfortunate enough to be labeled a suspect in this case. Which is another thing the state didn't show you. They didn't show you that there were 107 fingerprint suspects before Mr. Bundy's arrest, before or after. They never showed you that they compared anyone else's dentition. They only looked at Mr. Bundy's teeth and rotated them so they could make them fit the bite mark. The reasonable doubt here is shown by the actual models and the scientific facts and research that the state's theory of the bruise mark is not true, that Mr. Bundy's pattern is not unusual, and that the models have been shown to fit the bite mark. Dr. Levine said he had no database, and they're right. As well as Dr. Subron. But what he didn't tell you is that there is scientific evidence, scientific data, which is directly against their theory. They just didn't know as much as Dr. Gruey did about the study of the development and the patterns of teeth, and maladjustment, and misalignment. And they had no database and no information about the relative incidence of certain dental alignments. Another example of the reasonable doubt as to their opinions comes from the computer photograph shown you by Campbell. He testified that the purpose of this was to show 3 dimensions, but then he said that's not really 3 dimensions, it's really an optical illusion. That optical illusion is what Dr. Levine attempted to base his opinions on. If Dr. Levine were to tell you that your child had to have all his teeth pulled,
Objection.
you should ask for the reasons. And the state did not show you the reasons behind the opinions. No database, no objective standards. State's evidence, dental evidence, leaves you with 2 choices. You can find my client guilty of first-degree murder on unsupported opinion and optical illusions, and a new science that Subron says is part art, part science, subject to the interpretation of examiners. Or you can consider the evidence and use your common sense and consider the scientific studies and the data supplied to you by Dr. Gruey, and look to the durable evidence. Look to the models to reach only one possible conclusion: that the state has not proved that Mr. Bundy and no one else left those bite marks beyond and to the exclusion of a reasonable doubt. You cannot convict Mr. Bundy on these charges unless you are convinced beyond a reasonable doubt the state's dentists were right, and that Dr. Gruey and the science of orthodontistry and that the other models are wrong. In reference to the hair, in addition to the problems with the contamination of placing that pantyhose on the floor, Pat Lasko testified that prior to the time that she examined the hairs in this case, she had only had 1 week of formal FBI school training. She said her other training was on the job, without any reference to the competency of her original instructor. Like the dental evidence about the hair is, there's no standards. In large part, it's dependent upon the subjective interpretation of the examiner. And therefore, the examiner's subjective interpretation of what she sees in those hairs is going to be limited by her experience or her official training. She repeatedly stated that state of the science of hair comparison is only such that she can say whether they're similar or whether they're consistent or whether they could have come from. She said she couldn't make an identification. You can't make an identification on hair. It doesn't possess the sufficient characteristics. It's not like fingerprints. It can't be done. She also told him the same person can have different hairs, different characteristics, and that different people can also have similar hairs. And she said that there's no objective standard to determine similarity. It's based on her opinion as she's looking under the microscope in the lab at these two pieces of hair. And she came in and described the characteristics in terms to you. She didn't bring you a photograph. She didn't show you what they looked like under the slide so you could make up your mind for yourself as to whether or not she knew what she was talking about, as to whether or not those similarities are there. In the final analysis, as far as Ms. Lasker's testimony goes, she's saying the same thing to you as dental experts say. She's saying, trust me, I say it so. I'm an expert, you have to believe me. But again, I ask you, does trust me amount to proof beyond and to the exclusion of every reasonable doubt? We had read to you the deposition of Dr. Anderson concerning his analysis of the bark chips in order for you to see certain things that is evident or lacking from the state's evidence. His conclusions, his research about the kind of the species of bark, were that there were two kinds of bark, from water oak and laurel oak, and that there were two different diameters of logs. Laurel oak, which was 2 inches in diameter, and water oak, which was 2 1/4 to 2 1/2 inches in diameter. The significance of this was that Neary described one log being carried out of the house. If there were no blood tests done on any of the bark that was found at the area of the point of entry, or what the state would allege to be the point of entry, at the southwest corner where the combination lock was. And that the state's evidence can't establish whether that bark was dropped when someone was coming in or when someone was going out. It also shows that with no bark found at Dunwoody, there's no evidence as to that of any link between the scenes of both of those crimes. And that there would also, the state did not show you that the same person committed both acts because of the bark at Chi-Omega and no bark at Dunwoody. And the inference can be that there were two people inside the Chi-Omega house wielding two logs with two different diameters. Because Neary didn't see the second log being carried out. And the second log could have been the log that went out the southwest corner of the door, the combination lock. The serology evidence produced to you by Mr. Stevens, other than the fact that the victims bled when they were beaten in their beds. He testified about 3 types of body fluids: blood, saliva, and semen. He testified about a piece of gum which had been collected from the hair of Lisa Levy. And he testified about a stain that was found on the bed sheets of Cheryl Thomas, and another stain that was found on the bedspread. Mr. Stevens described to you the kind of test that he performed on the semen stain. He described the acid phosphatase test that he did in the first instance, in addition to seeing spermatozoa under the microscope, in order to determine that it was a semen stain. During Cheryl Thomas's testimony, it was established that the origin of the semen stain on the blood sheets was not in any way associated with her. She had washed the sheets and put on clean sheets on the bed that day. She stated that she had not had any sexual relations that night. The inference, the finding of that semen stain, as it was on that sheet, is that it was left by the person who came in to Cheryl Thomas's apartment. Mr. Stevens tested this stain by a test which was called absorption inhibition. And in performing the test, he described what controls he used. He took a piece of the sheet without a stain and placed it in the test tube as a control. In another test tube, he put a saliva sample from a known secretor of the type A blood type. And this was done to ensure that the sheet itself was not contaminated with other secretions, and to assure that the known samples caused the expected results. And then in the third test tube, he put the stain from the bed sheet. This resulted in the 3 test tubes being involved for the type O blood type examination. He used the same technique on the type B and on the type O blood groupings to determine whether those blood grouping factors were also present. Into the test tubes, he put the solution of the anti-serum, and he allowed the solution to react for a while. And then he added appropriate known cells from saliva to the solutions. In all of his tests, both as to the saliva sample taken from the gum and as to the semen stain, there was agglutination or clotting in all of the tubes containing the cloth that had the semen stain. We repeated this test several times using different sized pieces of the stain material. In all of the tests, he found the characteristic clotting or agglutination in those the test tubes that contained the stained cloth. In all of his 4 tests, the controls reacted as anticipated, indicating that his tests were conducted properly and that the unstained cloth did not reveal any contaminating body fluids. Although in his official reports, Mr. Stevens said that the tests were inconclusive, he admitted that clotting in all of the test tubes is consistent with the donor of the semen stain being a non-secretor.
15 minutes.
And he explained to you what a non-secretor was. There are certain persons that excrete their blood type in their body fluids other than their blood, such as semen or saliva or perspiration. If there had been any test tube in this group that failed to clot, it would have indicated that one of the ABO blood types was present and that the stain was left by a secretor. That was not the case. The same test was performed 6 times on a piece of gum that was found in Lisa Levy's hair. In all of the test tubes containing the questioned saliva from the gum, clotting was apparent. All of these tests were also consistent with the interpretation that the gum was chewed by a non-secretor. In all, 10 tests were performed and all had the same results. Clotting in the question tube. All 10 tests were validated by the controls performed by Dr. Stevens. And the controls he used, they eliminated any possibility tests were not properly conducted because there were no contaminating body fluids found on the control samples, and because the known saliva samples reacted as Mr. Stevens anticipated. In addition, his microscopic examination revealing the sperm stains indicated that the stain had not been washed. The acid phosphatase test revealed a strong reaction in a deep purple color, showed that the stain was easily capable of being tested further for the ABO blood type. And both of these tests show that the stain was recently made. Coupled with the testimony from Cheryl Thomas, that she was not in any way responsible, or it was not through her that the stain got on that bed, the inescapable conclusion is the stain was made by the assailant, and that the assailant is a non-secretor. Also inescapable is the conclusion that the gum in the hair of Lisa Levy was chewed by a non-secretor. Mr. Stevens did eventually test the semen stain on May 4th, 1979 for a PGM enzyme. Testified that even non-secretors will show the enzyme in their body fluids. But this nearly 4-month delay in testing allowed that fragile enzyme to deteriorate to the point of being no value. And this delay also resulted in the loss of important identification information. Mr. Stevens was then called by the defense. And he testified that he had taken a saliva sample from Mr. Bundy and examined it. And the examination revealed that Mr. Bundy was a secretor of the O-type blood group. Defense also called Michael Grubb, who is a criminalist with the Institute of Forensic Science in Oakland, California. Mr. Grubb testified to you concerning his experience, which includes examination of evidence in over 250 sexual assault cases, and independent research and authoring of papers in the field of serology, as well as the fact that he's previously been qualified as an expert to testify in court. Mr. Grubb obtained a semen sample from Mr. Bundy. He examined the sample microscopically for spermatozoa, and he located those cells. He proceeded to test it further. He used the same test that Mr. Stevens used, the absorption inhibition test. He conducted a total of 24 separate tests with varying degrees of dilution. He used dilution all the way from 1 part semen to 640 parts saline solution. In all of the tubes, in all of the tests, there was no clotting in the O-test tube. This indicates that Mr. Bundy is a secretor, and that the secretion of the antigens in his semen is so strong that a dilution of 1 part semen in 640 parts saline solution will still reveal the presence of the ABO blood factor in his semen. Mr. Grubb further testified that a delay of 3 months or even 3 years would not necessarily destroy the antigens in the semen stain. He stated that where a semen stain is tested using the absorption inhibition test, and even after the lapse of 4 to 18 months, where the controls validate the test, which Mr. Stevens explained to you in this case, the clotting in all of the question test tubes means that the person from which the semen stain came is a non-secretor. The multiple tests conducted by Mr. Stevens in his laboratory, in his controlled laboratory conditions, all having the same results, all indicate that the semen stain was left by a non-secretor. All of his tests on the gum indicate that that gum was chewed by a non-secretor. His elimination of all the contaminating factors, including deterioration caused by age, combined with the saliva and the semen tests that were done on Mr. Bundy, is affirmative proof that Mr. Bundy is not responsible for the gum being left in the hair of Lisa Levy. And And it's also a positive exclusion that he could not have left the semen stain that was found on Cheryl Thomas's bed. These proofs exclude him as being the perpetrator of these crimes. Ladies and gentlemen, before you retire to deliberate your verdict, I'd like to remind you that in our system of justice, that this isn't like a democracy. The vote is not by a majority vote. The vote is unanimous. The vote must be unanimous. All of you individually must believe, your conviction must find that the state has proved the case against my client, Mr. Bundy, beyond and to the exclusion of every reasonable doubt before you can convict him. Each of you has a vote. Each of you has a soul-searching decision to make. Each of you has control to stick to your convictions and to not render a verdict, to not vote along with the majority if you remained unconvinced. The evidence in this case presents many reasonable doubts as to Mr. Bundy's guilt. And I would ask you that when you retire to deliberate your verdict, that you consider the evidence carefully, and that you look at the evidence, and that you return with the only possible verdict, and that is not guilty. Thank you.
Mr. Simpson. Well, ladies and gentlemen, I guess the first thing we ought to do is issue a formal apology to Mr. Bundy and his whole defense team for dragging him through this 4-week trial we just had. Ladies and gentlemen, page 1, chapter 1 of the defense attorney's manual is, when all else fails, you put the police on trial. And that's exactly what they try to do in this case. And you can't do that. If you can't hang it on the police, then you try to hang it on the witnesses. You come along and you take this little statement that was taken in a deposition months and months ago. You take this little statement that came out of some recorded statement that was taken months and months ago, and you try to destroy a witness and their testimony with it. It doesn't work. It just doesn't work. Every one of you sat right here in this courtroom and watched as every witness took that witness stand and testified in this case. You've got the ability to sit and look and see the witnesses testify, to watch their demeanor while they testify, to evaluate their testimony in the light of all the evidence that's been presented in this case. Whenever I first stood up here and started talking to you, one of the first things I told you was, the defense is going to try to take this little piece of evidence and throw it away. And they're going to take this little piece of evidence, say it's no good, and throw it away too. You can't do that in this case. You have the benefit of knowing all the evidence right now. All of it. And that's what your verdict has got to be based on. You don't have to base a verdict solely on the testimony of Nita Neary, even though it's sufficient for conviction. You don't have to base your verdict solely on the testimony of Larry Wingfield and Bob Fulford, the guys that rented the room to Bundy at the Oaks. You don't have to base your verdict just solely upon the girls that saw this man in Sherrod's on the night of the murders. You don't have to base your verdict solely upon the testimony of Gage and Palumbo that saw him coming home that night after committing these brutal murders. You don't have to base your verdict solely upon the testimony of Deputy Dawes and Officer Dickey, who saw him 3 weeks after the crimes had been committed, and whenever he ran from Officer Dawes. You don't have to base your verdict in this case solely on the testimony of Officer Lee that arrested this man while he was hightailing it out of town over in Pensacola. And you don't have to base your verdict in this case solely upon the testimony of Patricia Lasco, who did the hair examinations in this case. And you don't have to base your verdict solely upon the testimony of Dr. Souron and Dr. Levine, who made a positive match of this defendant's teeth to the bite mark that was inflicted on the buttocks of Lisa Levy. You don't have to do that, ladies and gentlemen, because you have all the evidence. And you can consider each piece of that evidence along with every other piece of evidence and evaluate it together and base your verdict on all of the evidence, not just a part of it. Now, unfortunately, Ms. Good, the public defender that just argued to you, was not a witness in this case. She tried to be just a few minutes ago whenever she stood up here before you. She tried to tell you that there was proof positive that the defendant in this case did not commit these crimes because the semen stain that was left at the Dunwoody Street residence and the chewing gum that came from Lisa Levy were left by a non-secretor. That is not true. That is not the testimony that was presented here in this courtroom. The testimony in this courtroom came from Mr. Richard Stevens from that witness stand right there. He said he examined the semen stain, he examined the chewing gum, and if he said it once, he must have said it 10 times. The tests were inconclusive. That's all he could say about it. Then the defense jumped in here right at the end of their case and brought some guy in here all the way from Oakland, California to do his own test. And what kind of a test did he do? He did a test on Mr. Bundy's semen. They didn't even show him the exhibits. If he's such a hotshot, if he's so good at all this stuff, then why didn't they just, all they had to do was just pull the stuff right out of evidence and let him look at it, let him do his own test on it? No. This is just typical of the way in which this case has been defended from the very beginning. It's been defended on the basis of confusion, an attempt to discredit witnesses, and just total confusion. There's no other way to put it. They have not addressed the issues that have been presented in this case. Whenever Nita Neary took that stand and positively identified that man seated over there, they never asked her one question about the certainty of that identification. When Dr. Levine took the stand just yesterday, and he sat here and he says, I have looked at all 5 of these models that were presented to me, and I can exclude all of them except for Mr. Bundy. Did they even ask him why? No. It is typical of the way this case has been defended from the very beginning. They talked to you about the Connie Hastings and Carole Black being in Sherrod's on the night of this murder. I thought that was very important. There was no conflict between their testimonies, ladies and gentlemen. Connie Hastings told you that the man had a jacket on, dark jacket. She said he possibly had a turtleneck. The testimony of Carole Black was that he had a blue baseball type jacket on. He had lighter colored pants. And ladies and gentlemen, take that and put it with Nita Neary, and what do you have? What do you have? What was the description that Nita Neary gave the police and gave you right off of that witness stand? A man with a blue jacket on and light colored pants. Defense in this case stood up here and told you that the dental evidence in this case was no good. It was no good because there's no database to base all these conclusions and results on. But ladies and gentlemen, if there was ever any question in anybody's mind about the uniqueness of teeth, it was settled once and for all by Dr. Gruey, the defense's own expert in orthodontics. He took the witness stand, and I asked him on cross-examination, I said, what about this thing about uniqueness of teeth, doctor? And he says, well, I'll give you a good example. It's an example I used in Tallahassee. What did he tell you? He says, what about the chairs? You can look at those chairs, and whenever they came out of the manufacturer, they were all pretty much alike. But over a period of time, each and every one of them gets individual characteristics and acquired characteristics. Ladies and gentlemen, that's exactly what we've got in this case with those teeth. That's what allows those doctors, Dr. Suron and Dr. Levine, to come into court with such authority and tell you that with a reasonable degree of dental certainty, the defendant in this case made that bite mark. It's those individual and acquired characteristics. Now, let's talk about one other thing in this case. Ladies and gentlemen, the man that committed this crime was smart. This man premeditated this murder. He knew what he was going to do before he did it, and he planned it, and he prepared himself for it. And if there's any question in your mind about that, just look at that pantyhose mask. That is a weapon that was prepared by the perpetrator of this crime. Now, ladies and gentlemen, somebody that took the time to make this weapon right here, this instrument that could be used for both a mask or to hide identity, or also for strangulation. Anybody that took the time to do that is not going to leave fingerprints in a crime scene. Ladies and gentlemen, did you hear the testimony of Sergeant Bill Gunner of the Leon County Sheriff's Department? Whenever he went to room 12 at the Oaks to check on this defendant's room, he said that he dusted the whole room. There was not one single latent fingerprint in that room. The exact words of Sergeant Gunner was, the room had been wiped clean. Now, ladies and gentlemen, the person that committed this crime was smart. He was a person that was smart enough that whenever he got ready to get out of Tallahassee, he wasn't going to leave any traces there. The man that committed this crime was smart enough that whenever he got to Tallahassee, he wasn't going to check in anywhere by his right name. The man who committed this crime was smart enough, and professional enough that whenever it was over with and whenever he started to leave Tallahassee, he adopted the identification of yet another man, a man by the name of Ken Miser. And he even had his identification card with him. The man that committed this crime was smart enough that whenever he decided that he was going to adopt this kind of an identification, he went about and found out everything there was to know about this man and wrote it down in a book. Date of birth, February 7, 1949. Place of birth, Raleigh, North Carolina. Father's full name, Raymond Hugh Meisner. Mother's maiden name, Eleanor Travers. Social Security number, high school degree. Ladies and gentlemen, this man is a professional, just as he told Rusty Gage at the Oaks back in January of 1978. He's the kind of a man that's smart enough to stand up here in this courtroom, move to the end of that banister, and cross-examine witnesses in this case because he thinks he is smart enough to get away with any crime, just like he told Rusty Gage. But ladies and gentlemen, in this case, we were lucky. We were fortunate. In this case, we used some extraordinary efforts, some extraordinary evidence in order to bring this man to court today. Based on all of the evidence that's been presented in this case, it is your responsibility, it is your duty to return a verdict of guilty as charged. On behalf of all the people that have been involved in this case, myself, the witnesses, the law enforcement officers, the victims, their families, everybody, I want to thank you sincerely for the 4 weeks that y'all have taken out of your lives.
Mr. Watson. I think you can take it. Ladies and gentlemen, we're charged the jury and give charges right after the noon meal. I've tried to get them to return you in about an hour and a half. I think we can. We've met that schedule fairly consistently. So we'll resume again at 1:30, at which time the court will instruct you and you'll be allowed to begin your deliberations. We must again caution you during the lunch hour not to discuss this case among yourselves, nor with anyone else, for you still yet do not have all the tools that we've enumerated you with that you must have to begin your deliberations. I'll ask you to go now in the company of the court personnel and for your noon meeting.
Go right out the back door. There's someone out there to meet you. Y'all need the person. And Judge, we gotta get this stuff out of the jury room. Hold up just a minute. Everybody ready?